Our speaker is Cristiana Roda from Roda and Partner, so she's a lawyer too, and we start listening for your presentation. Thank you.
Thank you very much. Yes, as already Gianluca said, my speech will be about the ownership of AI-generated work. So my colleague Veronica told you about the input, and I will talk about the output. So our agenda for today, I will introduce you to IP rights, then I will discuss about IP rights and protection of AI-generated content, so under whether and under what condition AI-generated content could be protected, focusing on copyright and patent, and then I will give you possible scenario of ownership of AI-generated work, because the question, who is the ownership of AI-generated work, nowadays is a million-dollar question. So it is to understand the possible scenarios. So a brief introduction to IP rights. Intellectual property in general refers to a system of legal protection resulting from human creative, pay attention to human creative because will be relevant as we know, and inventive activity in the artistic, scientific, and industrial fields. Okay, let's focus on the two most IP rights relevant to AI-generated work, copyright and patent. Copyright protects the expressive form of an intellectual work with a creative nature. So copyright protects creative activity. Instead, patent protects technical solution to technical problem endowed with novelty and inventiveness. So patent protect inventive activity. But what could do an owner of an IP rights? The content of the IP rights consists in the exclusive right of the owner to exploit in any way and form its creation or invention or data. And so this is why it's so important to understand who owns these IP rights. So let's see whether and under what condition IP rights could protect AI-generated work. And we start with copyright. Just to let you know, as already Veronica said, AI Act gives a regulatory definition of a system AI is. Our focus today, my focus of my speech, will be generative artificial intelligence. And that it means any type of artificial intelligence capable of creating, in response to specific prompts, different types of content, such as text, images, and video. Let's start with copyright. Copyright, as already said, protects the expressive form of an intellectual work with a creative nature. And what aspects might be considered when assessing the eligibility for copyright protection of a subject matter created by AI tools? That was one of the questions that European Union raised last year and asked to all its member states in a policy questionnaire on the relationship between AI generative and copyright. And the result was that most all member states say that the works may be eligible for copyright protection only if the human input in their creative process was significant. And so, as a legal framework in Italy, if we see legal framework in Italy, for example, Article 20 of Italian copyright law talk about the right to claim an authorship of the work. Or, for example, the author 23 talk about death of the author, or, for example, the right provided in Article 20 could be exercised by heirs of the author. So, could you imagine the death of an AI system or the heirs of an AI system? I don't think so. And that's why a recent legislative amendment here in Italy modified the Article 1 on Italian copyright law The modifiers are underlined in red, so there was specified that only works of human creativity belonging to literature, music, visual arts, architecture, theater, and cinematography are protected under this law, regardless of the mode or form of expression, including those created with the aid of artificial intelligence tools, provided they are the result of the author's intellectual effort. What about, for example, USA? We see across the ocean. USA share the same principle that Europe, that I illustrated before about Europe and Italy. Because on our report released this year, the Copyright and Artificial Intelligence Office say that output will be copyrightable in whole or in part where AI is used as a tool, and where a human has been able to determine the expressive elements they contain. Prompts alone, however, at this stage are unlikely to satisfy those requirements. And that is the principle that both courts, but Copyright Office said. Because in a recent case of the US Court of Appeals for the District of Columbia, the court confirmed the denial of protection that Copyright Office did not release for the image because this image was created entirely by an artificial intelligence. So both Copyright Office and then court denied the protection, stated that the Copyright Act requires all eligible work to be authored in the first instance by a human being. Instead, another case of the US Copyright Office released copyright protection to the work because the author of this work was able to demonstrate that he interacted with the machine with the selection, coordination, and arrangement resulting from human creative input. What about patent? Patent protects the technical solution to technical problem endowed with novelty and inventiveness. Also for patents, European Patent Office gave on 2018 a guideline identifying 3 categories of invention that using AI in system. The first one is a human-made invention using AI for the verification of the outcome. The second one is where a human identifies a problem and uses AI tools to find a solution. And the third was an AI-made invention without human interaction. European Patent Office requires for the protection of patent that the inventor is a human being. And a landmark case on this issue was Dabus case. Dabus case was a system invented by Steven Thaler, who was able to generate something that Steven Thaler tried to patent. And the two questions was, AI can be inventor or not? European Patent Office said no. AI couldn't be inventor because European Patent Convention required that the inventor must be a human. So a machine couldn't identify as an inventor when a patent application is filed. The only, like Europe, also United States, Australia, and United Kingdom refused the application. The only one state who recognized the protection for the invention was South Africa. And the South Africa released the patent to Steven Thaler, who indicated AI as inventor, and it's the first patent granted for an AI invention. Also, legal framework in Italy confirms that, because as already said before for copyright, the Italian Industrial Property Code stated that, for example, the right to be recognized as the author of the invention may be claimed by the inventor and, after his death, like before, his spouse and descendants. So, can you imagine here, death? And so, but the important thing is that the requirement provided by law to the recognition of copyright and patent must be present. Even if human interaction is involved in the creation of AI-generated work, law requires that legal standards are met. So it is to assess case by case the protection, and there is no rule that could say to you, yes, you could protect your work if the human creativity is involved. This must assess case by case. I imagine, for example, by a judge. So having said that, who can claim the ownership of this work? I could imagine two possible scenarios. It could be the user, so the person who provided input and exercised creative control, or, for example, the developer of AI-generated AI system. In this sense, contracts and licensing agreements are essential in order to better understand who is the owner of a work. And that's an example of terms of use of OpenAI, that OpenAI stated that the ownership of the content is recognized to the user. In fact, you means refers to user. You retain your ownership rights in input and own the output. We hereby assign to you all our right, title, and interest, if any, in and to output. So, in conclusion, some consideration and one advice. Some consideration. At this stage, IP law remains human-centric. The human is in the center of the protection. Law incoming here must keep up with technological changes and stay flexible due to changes that run very fast. And then my advice as a lawyer is to read carefully terms and conditions of AI system you intend to use to generate your content. Thank you very much for the attention.
Thank you, Cristiana, for your speech. We have a couple of minutes for questions, if there are any. There is one here in front. Thank you.
Thanks for your explanation. I find I do not find in your explanation the right or the description of the roles of the person who is or the entity who is involved in the generation of artificial AI or machine learning system that may be used. So behind every system there is one or more human being who developed that system. So the role of that creator of the AI system, I find that was not fully just in the last slide you mentioned it. But my opinion is that that is quite important, because also that entities has a role, and maybe they must have some gain of the usage of the AI. And so, because we are using an engine AI, so-called AI, for doing elaboration of data in input who gives an output. So the model, but that is something which has created. So the interaction between the creator of the AI system and the user of the AI system is not very clear. Just maybe there is a formal contract.
Yes, thank you very much for your advice and consideration. I know, but I have only 15 minutes, so I decide to talk about rights and give you possible scenarios, but thank you for the advice. It's appreciated.